So by now we've gone through the final status conference, and we've gone through the trial call, and now you're actually at the department. So let's just say you're in Van Nuys, uh, courthouse east, which is the civil courthouse. West is the criminal. So you're now in Van Nuys East. What do you? And it's Wednesday. Let's just say. What are you gonna do? Well, on Wednesday, you're probably gonna meet your judge, and you're gonna show up. Let's just say at 9 a.m. And you're gonna show up, and Van Nuys East has a lot of trial judges, and you're been assigned to one department for the entire trial. You're gonna go meet that judge, and you're bringing to that judge 5 exhibit binders, 5 trial readiness binders, and you can use the courtroom to camp out. You don't have to take all of them back and forth to your car and to your home. You just use it to camp out. For the most part, judges have no problem. They kind of have to because it's easier for everybody. So you show up, and what do you do? Well, the judge is going to say hello. There's a chance that the judge might see if there's an ability to settle the case. But most likely, if you're there, it's not going to. There's no point, right? Unless you're very close, but you should have settled it before if you're very close. So there might be a question or two about settlement, but no willing settlement. There's no point because too far apart. Okay. The judge is going to take a look because these judges are very busy. They're trying a lot of cases. They probably the department one sent the book to him by email, the final status conference book, and they have access to the exhibits and all that. Actually, they have access to the exhibit list. The exhibits aren't filed, so they now see what the case is about. Car accident case, time estimate 4 to 5 days. Okay. They're going to talk to both attorneys, and the judge, depending on the way the judge runs the court, is going to explain, this is how I try cases. We start trial at 9 a.m. and we go until 4:30. Start at 9. We have our break at 11, 15-minute break. Then we go until noon. Then we come back at 1:30. We go from 1:30 until 3, 15-minute break, and we go until 4:30. Something that needs to be considered then and there is your court reporter. Defense counsel almost always will pay for the court reporter, but as a result, you won't have access to the court reporter. You won't have access to the dailies. If it's a big case, you might want to consider splitting the court reporter. The dailies are basically the daily report, the rush daily reports will set in trial. That's really useful on a big case because an opening statement, usually both sides will say something that isn't fully delivered accurately to the jury, in the sense that it's a promise that hasn't been kept, not because they didn't want to keep it, but because the evidence just didn't come in or whatever. It's kind of like one of those fact-checking moments that the Washington Post whatever would do. So the dailies are useful because you see what the opposing side said in opening statement, and none of it came in, or it came in different ways through the witnesses' statements, and you're like, whoa, their entire case, they said they're going to give you 1, 2, and 3, and they gave you 1, 2, and not really 3. I mean, that's something that in closing argument. So you want to consider the court reporter, the agency. There's a big shortage of court reporters in California. So, Coalition Court Reporter is a good court reporting service to use. Atkinson Baker, bought by Veritex. They're really good. So you want to take a look at court reporters. If it's a big case, both sides should pay for it. Plaintiffs usually don't pay for it if it's a small case, but that's something you need to consider for closing argument, and obviously for if it comes to that, it's a big case for appellate reasons. You can always pay for it at the end, but it's harder to get that for closing argument. So that's something that's important to take into account. The other aspect is the judge is going to talk to you about putting together just scheduling, which is who's going to go first. Are they going to take people out of order? what you can do. Trials are not, they don't have to all be at the same time. Meaning, you don't. It doesn't. Evidence can come in, and there's a jury instruction on this. It doesn't have to come in. You could put, you know, the defendant on, and then put on your doctors and then your accident recon, because that's the only time they're available, and then put on your client, and then it's scheduling is very much important. And then obviously the judge is going to mention that witnesses are excluded, which is a way of saying that if you're not a party to the case, your accident recon can't come in there on Monday and you hear how the accident occurred from the plaintiff or the defendant or both, and then come in there on Tuesday and Wednesday and then change their testimony or have that help. It's excluded; they can't hear that. So the judge will then look through the binders, and then at some point the judge is going to start ruling on these motions to eliminate. They're basically evidentiary objections. They're going to go through the ones that are stipulated, agreed to. Those don't need to be discussed. Then the judge is going to go through the ones that the plaintiff filed, and the defense filed, the ones that are opposed, not opposed. The judge is going to issue tentative rulings. Motions to eliminate can be made, can be revisited during trial, and they can be motions to eliminate. Actually, you can make them during trial as well. But the judge will rule on the motions to eliminate, and that's probably a good portion of the morning if you show up in the morning. If it's a Wednesday, let's just say you showed up on a Wednesday, there's a chance that you might have a jury panel ordered in on Thursday. But the chances that one is ordered and shows up by 1:30 is minimal, because they probably ordered one in that already went to some other trials, or were people that were excused or whatever, and you might want to wait for one on the next day, a fresh panel. So if it's a Wednesday, you might show up at 9 o'clock in the judge's courtroom. Maybe you go in chambers briefly for a settlement conversation, which might not be successful, and then motions to eliminate, go through everything, all the witnesses and everything. I'll say, okay, well, I'll see you guys back tomorrow. We'll order a jury panel, and then you just show up the next day. So the real question about all of this is, fine, but what are the lawyers and what are the clients really doing during all this time? Because it sounds like it's a lot of getting ready, it's a lot of paperwork, it's really paper intensive, it's really get up and go and wait, and that's all true. I would argue to you that the most important part is not what I call this. This is kind of like in the olden days when you buy a suit, they'd just give you the material, and then somebody would put it together after they get your measurements. I'd argue that the material is the most important part, not putting together the suit. Which is, the case is really won or lost based upon the client and how strong the client can relate to the jury. My opinion, my favorite book, well, a good book to read on this matter is this book called Trial by Human, in which it's written by Nick Rowley. In my opinion, one of the best, if not the best, plaintiff civil trial lawyer. And Rowley basically says, look, forget depositions, forget all of this, meet the client. Okay. Don't meet the client in your office, maybe don't even have a suit on, just t-shirt, jeans, fine. If that's too informal for you, wear what you want to wear, but meet them in a place where the client's not going to feel like they're just meeting another lawyer. Maybe take them out to dinner, meet them in their home. And then what I do at the risk of boring my client, is I talk about the client's life, where they're from, what they like to do, who they are, and then I talk about the case. I believe very much that in the plaintiff's arena, and in the defense arena too, but I don't think it's as needed in the defense arena, you have to try the case with the human. You have to do trial by human. If the human being is not presenting the trial, the case, and if it's just about a small segment of that person's life, how some car hit another car, and how the body moved and all that, that's not a full analysis, in my opinion, a fair analysis either for the jury. The reason why I say that is the defense always wants to keep the case to the bare bones minimums, what they call the facts. And it works really easily for them. And we could spend, an hour talking about the tort reform agenda and how effective it really is. But set that aside for a second. People, at the end of the day, are impacted by events more so than 20 minutes on a freeway. But they're hesitant to talk about it because they don't feel comfortable. They don't feel comfortable doing it in front of an open forum. They just don't. It's just not something that most human beings, right, are taught to. I would bring my wife to jury selection to see other lawyers try cases and pick juries. And she is a really good person in general, but she's a really good person at seeing people twitch and turn and body language and everything. But like most people, she's scared of public speaking. She always would say, "Can we sit in the back?" I'm always, "Let's sit up front." That's my thing. And that's your juror, but that's also your client. I've represented people that are Marines, and they've fought in Iraq, but they still would not want to talk in front of a jury. And if you're able to tap into their life, and at the end of the day, if this is a righteous case, and if it impacted their life, and you're able and you're willing to spend the time with them and ask them, how did this impact your life? Joe, John, Simon, Keone, Brittany, or not? How did it not impact your life? Then you're more likely to get the jury to understand what happened. Because the defense has a very scripted way of doing things. And it works, not because necessarily their lawyers are great at a script, but because the defense industry has scripted American society to making us believe that the civil justice system is a scam, and that anyone who complains is basically using our court system in a manner to redistribute wealth. And if you don't realize that, you're at a massive disadvantage because you're already playing on their terrain. I'm going to do an entire segment on jury deselection, because it's not jury selection, it's jury deselection. But know this, the minute you walked into that courtroom, the minute you walked into that department, even if it's California, even if it's Southern West Virginia in the 1980s, you need to consider that there is a defense bias against you. against the lawyer. The only person that's more disliked than the plaintiff is the plaintiff's attorney. And you need to realize how they're going to make it into numbers and segments and ideas that don't really make sense, other than an idea to get your client the minimum amount of compensation necessary so that they can walk out of there with a discount. Because that's really what the insurance defense industry is. It's the insurance defense industry. They're defending an insurance company so that that insurance company can pay out the minimum amount so that the next person who's injured doesn't seek justice, so that they understand that you don't go up against the big guys. And if you, the lawyer, don't know what you're doing, and don't know how they see it, then you're only doing your client a disservice. So I can talk to you about all day how to put together trial documents. But what you really need to do is realize how the defense sees the case, which means you need to know your client. And you need to be brutally honest with yourself of whether there actually is a case or not. Because if there is one, then you better fight like hell.